Okay, we're going to go ahead and get started. Peter Walson is on his way, we hope. But so we're just going to go ahead and get started. So thank you all for coming today to the Center for the Study of the Administrative State's Public Policy Conference on Financial Regulation. My name is Naomi Rao, and I'm the founder and director of the center. So the center has a simple yet challenging mission to examine the problems of the administrative state at their foundations. Through academic research and public policy outreach, we hope to develop responses to structural problems of administration, focusing on lack of accountability, diminished due process, and threats to individual and economic liberty. We aim to bring together people from different perspectives to address some of these very difficult issues. And today's conference focuses on an area in which the pathologies of the administrative state are really in stark relief. Since the 2010 Dodd-Frank Act, financial regulation has exploded. The Act created a number of new entities with a number of new expansive regulatory powers. 6 years later, however, the momentum has started to build for reform in all three branches of the government. President-elect Trump has vowed to dismantle Dodd-Frank. Members of Congress have been continually introducing new reforms to both the authority and the agencies under the Act. And the D.C. Circuit has recently found unconstitutional the independent structure of the Consumer Financial Protection Bureau. So in many ways, our conference today could not be more timely. We have leading academics, public policy experts, and experienced practitioners to look closer at these issues and to consider how to make financial regulatory agencies more accountable. I also know that a number of members in the audience are very involved with working on these issues, and we're going to leave time on each panel to ask questions, so we encourage you all to be involved with the discussion. I'd also like to say I've learned in the past year that these conferences require a lot of work and a lot of different pieces to come together. And so I just wanted to thank Dean Henry Butler, who will be here later today, for all of his very strong support of the center and its work. I'd like to especially acknowledge Leah Verbitsky, who is our new events coordinator. She is responsible for all of the logistics of this event and has been doing a fantastic job. And I really appreciate all of our speakers today for taking the time out of their very busy schedules to participate in the conference. I also wanted to mention, and this will become apparent on the panels, that 5 of our panelists wrote papers, underlying papers that are forming the basis of this conference. And they'll be talking about their papers on the panels, and you can find drafts of those papers on our website. So thank you again for coming today. We hope to see you at future events at the center. With that, I will leave it to Brian Brooks of Fannie Mae, who will be moderating our first panel. And I wanted to also mention that all of the biographical information for all the speakers can be found in your booklets. Thank you.
Well, thanks, Naomi, and thanks everybody to be here. This is just a terrific event. We're thrilled to be participating. Hopefully, am I close to the mic and audible? Great. So first of all, let me introduce myself. I'll say a few words about the format today. I will then introduce this distinguished panel. Is it made more distinguished by Peter's absence, or it'll be more distinguished when Peter gets here? Yeah, I think the latter for sure.
The latter. He's our anchor.
So first of all, let me just introduce myself. I'm Brian Brooks. I'm General Counsel of Fannie Mae. I will begin with the usual disclaimer that any views I should accidentally express are my own, do not reflect the views of Fannie Mae or the conservator or the United States government, and I hope not to express any views of any kind to begin with. We have a distinguished panel who comes at the issues today both from an academic and a professional perspective, and I think we have a lot to learn from the dialogue you're going to hear today. So let me just introduce, for those who don't know any one of these really all-star lawyers, to you. So to my immediate right is Todd Henderson, the Michael J. Marks Professor of Law at my alma mater, the University of Chicago Law School. Todd is himself a graduate of Chicago, which tells you the kind of dialogue you're going to have on this amazing panel. But those are not anywhere close to Todd's greatest distinctions. Todd's really famous, I'm sure you're excited for this part of the introduction, Todd's really famous for having won the University of Chicago intramural football championship. Now, for those of you who don't know, the University of Chicago actual Division III football team is the only football team to have an all-time positive win-loss record against Notre Dame, having last played that game in 1917. And so Todd's distinction in this regard is perhaps even greater than the intellectual dialogue he's going to contribute today. To Todd's right is my friend Elizabeth Pepez, who is a well-known partner at the Winston & Strawn law firm here in Washington. Elizabeth clerked for what I think by common consensus is the best of the Court of Appeals judges, Judge Danny Boggs on the Sixth Circuit, where I also happen to clerk. You can see there's a little bit of nepotism going on up here. And later in her career, clerked for Justice Thomas on the Supreme Court. Elizabeth was a Deputy Assistant Attorney General in the Office of Legal Counsel, has been around Washington, has been around policy issues, including financial services regulatory issues, for a very long time. To her right is an empty chair that we are currently saving for my friend Peter Wallison, who is, I think it's probably not an overstatement to say, perhaps the most distinguished commentator on financial policy issues of his generation, except for Richard Epstein, who is the other most distinguished and beloved person in this field.
Oh, you again!
Here I am. So I get that a lot. This is true. So Peter, we think, is on his way, and all of you know Peter. Peter is the former White House counsel, the former Treasury General counsel, perhaps most well-known dissenting voice on the Financial Crisis Inquiry Commission. Peter has been writing about issues about SIFIs and systemic risk for a very long time. He'll be joining us shortly. And finally, last but not least, is my friend and former colleague Adam White, who is a research fellow at the Hoover Institution, of counsel at Boyd & Gray & Associates, and one of the architects of the constitutional challenge to the Consumer Financial Protection Bureau, among many other distinctions. So with that, the format today is each panelist is going to give us 8 to 10 minutes of thoughts, some derived from papers, some derived from other thinking around these systemic risk issues. And once each person has spoken, and we'll just go in turn, starting with Elizabeth, we will then open it up for dialogue among the panelists and questions from the audience. So Elizabeth, let me turn it over to you to start, if I could.
Thanks, Brian, and thanks, Naomi and the Center, for the opportunity to be here today. This is obviously a great conference, timely issues, and it's a pleasure to be on such a distinguished panel. I must confess, my colleagues today are much more steeped than I in some of the most timely policy issues we'll be discussing today, so I thought I might start with just a couple of words about the framework we were hoping to discuss today, with maybe some anecdotal observations from my time, both at the Justice Department, where I was in the Office of Legal Counsel, but worked heavily on issues of financial regulation, including with Treasury and Congress on the TARP at the time, and then subsequently in private practice, where a lot of my clients live every day with some of the regulations and risk issues we're discussing. Obviously, like Brian, any views I happen to express today are my own, don't purport to represent the positions of clients. But I do think that there's a sort of practical aspect to this that all of our panelists today will address. And the framework we were thinking of is sort of the normal two-part framework of systemic risk. I think at a high level everyone agrees is an important issue. I think there's obviously broad consensus. Failures are bad, right? Increasing margin and capitalization requirements is good, and reducing leverage ratios is good. Beyond that, things sort of go in very different directions, and I think we're at a point now, whatever we are, 6-8 years past the crisis, where we can look back and see, some of the intended and, more importantly, unintended consequences of the regulatory response. And the framework we were thinking about addressing was, first, where do you do this kind of regulation? I think we've gotten some lessons, and there's some current legislation pending and rulemakings and other things that we can talk about. But one is, where do you do systemic risk regulation, right? There's sort of the obvious starting point, which is Congress, and you can start with legislation, and we'll talk about that level. And I think Todd and others will talk about some of the issues there, the administrative law and other issues that attend that, particularly delegation and some of the other problems. And then the second step is, if not at the legislative level, then where? It's typically at the agency level, and some of the issues that go with that. And I think you have to start as a constitutional matter, with Congress on some of these issues. But when we look back at Dodd-Frank, I think there is some consensus that there are a lot of issues. I think that there's current legislation pending that's taking some steps in the right direction. The bill that the House passed, I think it was at the beginning of the month on December 2nd, H.R. 6392, which is the Systemic Risk Designation Improvement Act. That sort of recognizes that a broad brush approach of saying, that special regulation based on, asset size alone is maybe not the right answer. So I think, at the legislative level, there's a recognition that we need to be a little bit more calibrated about this. And I think that's a lesson that all of us have learned, regardless of our walk, whether it's in the policy arena, in my case, since I left the government, in private practice, where many of my clients struggle every day with balancing a very complicated matrix of things under these risk regulations. And then the next piece is, if legislation like the House bill gets enacted, you're now into the administrative framework. And so that leads to the question of how do we address systemic risk at the agency level? And I think that is something that, we could spend much of the day today discussing, and we will. I think some of the lessons we've learned are going to be addressed by the other panelists. What I would say from sort of my limited exposure, again, in justice and in private practice, is that a big piece of it, and I think it's increasingly important going forward, is collaboration and sort of information transparency. One of the things that sort of I've noticed, and again, this is just anecdotal, is that obviously regulation of some of these issues is extremely complex in these very highly liquid, deep markets. And some of the unintended consequences of regulation to date have not adequately accounted for the impact on whether it's financial institutions or secondary institutions in other areas. And I mean that from a policy standpoint. I think there are areas like national security or antitrust that are implicated by some of the primary systemic risk and financial services regulations that no one really foresaw. And I think if we look back, we can see how we might do better on that going forward. And the other thing is information flow in markets. And this is sort of the observation I'll close with before I turn it over to Todd. One of the things I think has happened with systemic risk regulation is it has touched upon areas, particularly in my experience in financial institutions, that serve important purposes for liquidity provision, both for market making and then for other purposes. And I don't know that there was adequate thought given to how some of the regulatory responses, and particularly restrictions on whether it was increased capitalization requirements combined with limits on things like proprietary trading or hedging, might affect a financial institution's ability to serve as a market maker, and in turn to provide liquidity to U.S. markets, and in turn to expose our markets to increased investment by foreign entities that pose the kind of national security concerns that I referenced and we deal with in the Justice Department every day, both in terms of sort of routine CFIUS issues, but then on a more calibrated level, depending on who's participating in our bond markets and auctions and things like that. So I think there's a level about that, and the other impact of the regulations, apart from just the impact on liquidity provision and overall functioning of our U.S. financial institutions, was how much of the regulatory framework changed the direction or the matrix of information flow in financial markets. This is something that some folks at the New York Fed staff have studied recently, some folks at the Treasury have looked at, that I think is extremely interesting and should be studied further, and it should be part of the dialogue between industry and regulators, and I think it increasingly is, about how regulation affects information flow in channels that are important to the functioning of overall financial markets and institutions and the provision of liquidity. So with that, I will turn it over to Todd. Or sorry, is it Adam?
It's Adam.
Oh, Adam. Sorry, I thought Todd was second in the lineup. So now we're going really all the way to the end. So hey, Peter.
All right.
All yours.
All right, and I think they're going to load a couple of slides up on the screen. But let me just start by backing up from the details a little bit, just to ask a practical question. How do you guard against dangers that you can't predict? Now, of course, the future is always somewhat mysterious, only because it hasn't happened yet, but some predictions are easier to make than others. For some questions, the past is a pretty reliable hint of what's to come. I feel pretty confident predicting the sun will rise tomorrow. I also feel reasonably confident predicting that Richard Epstein will say at least 3 profound things at lunch today. But what about the precise location of the next domestic terror attack? Or the nature of the next pandemic? Thanks. Or the cause of the next global financial crisis? And that's the question that I think is reflected well by the cartoon that I had in the version of the paper I originally circulated, but cut for copyright reasons. This appeared in Barron's magazine last year. If you can't read the caption, one businessman is saying to the other, we're still at the stage where we're missing the warning signs. And the point being, we know there's a threat out there, we just don't know exactly what it is. We don't even know how to look for it. For these sorts of threats, the past is too poor an indicator of what's to come. Only after crisis strikes do we realize what we should have been looking for. And our analysis at that point is corrupted by the fact that when such an event actually comes to pass, we can look backwards and reverse engineer an explanation for why we should have seen it coming. Roberta Wohlstetter, author of a famous analysis of the Pearl Harbor attacks, once wrote that, quote, "It is much easier after the event to sort the relevant from the irrelevant signals. After the event, of course, a signal is always crystal clear. We can now see what disaster it was signaling since the disaster has occurred. But before the event, it is obscure and pregnant with conflicting meanings." Wohlstetter's lesson is that there's a danger when we look back oversimplistically at past events, because we tend also to oversimplify our analysis as we look forward, guarding against the next disaster. In the 9/11 Commission report, for example, the authors of the report subtly acknowledged this when they noted that their analysis of the 9/11 attacks reflected both, quote, "the benefit and handicap of hindsight." That's a very apt phrase, the benefit of hindsight and the handicap of hindsight. And that's the premise of my article that I prepared for this conference. As its title indicates, I've been thinking about the Financial Stability Oversight Council, an interagency body that Congress created in the aftermath of the last financial crisis to guard against what we call systemic financial risk. That is, the risk of threats to the overall stability of our financial system. It was an issue that, as Elizabeth indicated, came to the forefront of policy discussions in the immediate aftermath of the last financial crisis, when there was a sense that the failure of individual firms, from investment banks like Bear Stearns to non-bank institutions like AIG, threatened to explode the entire national or international financial system and thus required emergency bailouts at the time. The framers of the Dodd-Frank Act concluded that federal regulators would need to take preemptive action to identify systemically important financial institutions, call them SIFIs, and to subject them to extra regulation and oversight in order to prevent them from disrupting national financial stability. Dodd-Frank created a 10-member interagency board chaired by the Treasury Secretary and featuring other federal regulators, including Federal Reserve Chairman, the Chairman of the SEC, as well as a state insurance regulatory expert. This 10-member board would identify, under Dodd-Frank, would identify non-bank, systemically important financial institutions and subject them to heightened supervision by the Federal Reserve. This interagency body was again titled the Financial Stability Oversight Council, or FSOC. So what standards would the FSOC apply in designating non-bank institutions as systemically important? Well, Congress specified that FSOC would consider two basic types of systemic risk. One, that material financial distress at the company, or two, the company's nature, scope, size, scale, concentration, interconnectedness, or mix of activities. Either of those two factors could pose a threat to the financial stability of the United States. On its own terms, the Act sets a seemingly low bar for designations. The FSOC only has to decide that the company could pose a threat to financial stability. And the Act further specified a non-exhaustive list of 10 factors for the FSOC to consider in making its determination. The extent of the company's leverage, its off-balance sheet exposures, its importance as a source of credit, and the catch-all factor, quote, any other risk-related factors that the council deems appropriate. In other words, Congress gave FSOC an effectively open-ended statutory framework. And even then, in the aftermath of that, the FSOC has still found it necessary to effectively rewrite the statute, creating its own completely new framework for analysis. So far, the FSOC has designated 4 non-bank institutions as systemically important: AIG, GE Capital, and then two more run-of-the-mill insurance companies, Prudential and MetLife. And in making those determinations, especially the last two, the insurance companies, it is very difficult not to conclude, as I explain in my paper, that the FSOC's actions are completely arbitrary. They've singled out a couple of institutions and designated them based on conjecture about their interconnectedness and size. And one of these, the MetLife designation, is right now the subject of DC Circuit litigation. I don't particularly blame FSOC for acting arbitrarily, because as I explained in my paper, I think it's difficult, maybe impossible, for the FSOC to go about its work in a non-arbitrary way under the framework that Congress created. Simply put, there's no real consensus on what systemic risk is, what causes it, what evidence predicts it, and so on. And too often, there's no meaningful evidence of trouble ahead. A couple of days ago in my office at Hoover, the economist John Cochran, who recently joined us from the University of Chicago, he was talking about systemic risk, and he said terms like systemic risk and macroprudential risk management are terms that we've basically invented in the last 5 years, and you say them as fast as you can in the hopes that no one notices that you actually don't know what you're saying when you say these words. They're just words we still haven't really built any content into. The best explanation of this problem came from none other than Treasury Secretary Tim Geithner, the FSOC's first chairman, in a 2011 interview to the Special Inspector General for the Troubled Asset Relief Program. And he said, this is the quote here, "What size and mix of business do you classify as systemic? It depends too much on the state of the world at the time. You won't be able to make a judgment about what's systemic and what's not until you know the nature of the shock that the economy is undergoing." We don't know until after the fact whether something was systemic. And this is the first chairman of the FSOC saying this. Now, in practice, the FSOC's decisions, at least their public decisions and deliberations, have been extremely glib, leaving its proponents, the FSOC's proponents, to argue that courts should simply defer to what they call FSOC's predictive judgment. And while, yes, the courts often do defer to an agency's predictive judgment, they do so when the judgments are rooted at least somewhat in record evidence. It's predictions based on evidence, not predictions in lieu of evidence. To defer to predictions without a real basis in the record is, to borrow a line from Jeremy Bentham, like deferring to nonsense on stilts. There's no real basis for the thing you're deferring to. That's why I say in my paper, I ask at least, whether FSOC is too big for administrative law. Its basic mission and standards drive it to make decisions that can't satisfy the standards of ordinary administrative law. Ultimately, and we can get into this, Congress will need to change Dodd-Frank to suit administrative law, or it will need to change administrative law to suit Dodd-Frank, one or the other. And just a postscript, I focused on this issue not just because I think it's important in and of itself, although I think it is important in and of itself, and I've been involved with Boyd and Gray and others in legal challenges to the FSOC. I think it's a model of what's to come in regulation. Agencies are no longer regulating just the low-hanging regulatory fruit. Congress is now charging agencies or agencies are claiming the mission of tackling ever bigger problems. Problems, whether it's climate change, pandemics, the threat of terrorism, and its impacts on energy infrastructure. It's ever broader conjecture, looking further into the future. So many of these problems, like systemic risk, where we don't really know what we're looking for. And the answer can't just be for Congress to hand over an open regulatory a blank regulatory check to the agency and say, go do your best. It's going to require Congress to grapple with these things seriously, using the advice and expertise of bodies like FSOC, but ultimately Congress is going to have to make some tough decisions itself, or we're going to keep running into these administrative law problems over and over again. That's all. With that, I'll turn it over to Todd.
Great, thanks. I want to point out mine is the only microphone without a wire here, and I don't know if that is on purpose. It's trying to keep me from communicating, but I'll speak up so you can hear me.
Borrow this one.
No, that's okay. So I just want to respond quickly to, so thanks to Naomi for having me and for you all for coming. I want to just respond quickly to two things that Adam said. The first one is he said, I'm not sure where the next failure is going to come from or the cause of the next financial crisis. And the answer to that we all know, which is bad government policy. So that's not a surprise. I don't know which bad government policy it's going to be, but that's going to be the cause of it. The other thing is this point that Cochran made. I have no idea what systemic risk means. I've yet to hear anybody offer an explanation other than something like good old-fashioned bank runs. But it's not obvious why the failure of any institution as an institution would cause a bank run, given that next door is the FDIC. And so what really matters, I'm far from an expert in banking law, but what really seems to matter to me is correlated risk in the financial sector, not the size of a particular bank. If you've got a bunch of small banks that all have correlated risks, and for whatever reason there's a shock that changes the risk valuations of those businesses, that's what causes a financial crisis. So, I mean, I'm old enough that I was alive during the savings and loan crisis, and there was nothing too big about any Lincoln Savings and Loan. So that seems to me to be the real problem. So when people use the systemic risk, I agree with Adam. It's just like these magic words that are supposed to scare you into giving more power to the government, and that's really bad. Okay. How do I think about this? So, you know, I had torts. I'm just a country lawyer. I think about tort law as it applies to regulation. The problem with banking is government insurance is a necessary precondition, we think, to solving the bank run problem, which can cause even solvent financial institutions to run into trouble for kind of irrational behavior by people. And so that creates this moral hazard problem. How do we address that? I mean, you know, even small government guys like Richard and me believe in pretty strict banking regulation. So how do we approach it? Well, there's two approaches, just like all regulation. You can regulate ex ante, you can regulate ex post. Ex post doesn't really work so well in financial regulation because the judgment proofness problem really swamps everything. In torts, Steve Chevelle and others say, well, we can solve the ex post judgment proofness problem with insurance. And again, insurance doesn't work so well in financial regulation, just given the size of the risks. And as the financial crisis suggested, you know, the financial system goes down, the insurance industry is probably going to go down too. So ex post regulation doesn't work so well. Ex ante regulation is what we mostly have. And the problem with ex ante regulation, things like capital adequacy requirements and prudential regulations, and people have proposed things like executive compensation changes and bank size limits. The problem with these, as all ex ante regulation, is lack of information. So the regulators don't have good information about the choices that banks are going to make. They don't have information about the private value for banks, the social value. This is, you know, I care more about social value than about private value because I'm a law professor. I can get away with being a welfare resident. They don't have good information about the social value of bank activities. How do loans contribute to the welfare of all of us? That's what we really care about, and regulators don't have good insights of that. Ex ante rules are also typically, whether they come from the legislature or the administrative agency, one size fits all approaches. Bank size limits of a certain amount or capital adequacy rules of a certain amount. Those rules are necessarily going to be over and under inclusive, especially when regulators with informational deficits are making judgments before anybody's engaged in any activity. Okay, so some of the solutions that have been offered in the wake of the financial crisis, size limits, John Macy and others, there's some books about this, transaction taxes. My colleague Eric Posner proposed a FDA for the financial industry. There's the Volcker rule. All these are versions of ex ante regulations, and the application of these, so just take the Volcker rule for example, you can see the problem of information problems for regulators, trying to predict what bad activities are and write that into a rule. I've yet to hear anybody offer any positive spin on the attempts by the regulators to come up with a difference between hedging and speculation. You cannot do it. We could get the smartest people and we could bring Watson from IBM in here and get him on the job. No regulators are going to be able to write an ex ante rule that tells us the difference between hedging and speculation. This is something we could only know in practice. So something like government policy that said, we will bail you out unless you engage in bad conduct. That's it, that's the rule. And then we let people decide what they think bad conduct is, and then the government makes a judgment afterwards. A rule like that could possibly work, but we can't really imagine that being government policy. But having a bunch of lawyers write 10,000 words about what is the difference between hedging and speculation, we can't do it. It's gonna be avoided by clever practitioners and people who are engaging in financial engineering and innovation, and it's gonna be causing costs downstream that we can't predict. Capital adequacy rules, again, all well and good if what you're worried about is shareholders of the banks stealing from debt holders of the banks. Capital adequacy does that because it provides a kind of deductible for the losses that are coming. Capital adequacy rules don't do anything to discourage shareholders from externalizing risk onto the public. They don't discourage banks from taking risks. If you tell banks you can't be bigger than a certain amount of size, that's going to change the projects that banks choose to invest in. Banks will engage in more risk if you tell them they have to be smaller. We've already seen some evidence of this. So if what we're really worried about is externalizing, like in torts, we worry about people externalizing costs onto other people, capital adequacy is not going to solve that particular problem. Okay, so this in the paper, my co-author and I then say, there is this kind of interesting feature of bank regulation that is halfway between ex ante and ex post. We call it the regulatory veto, and this is a familiar thing for people who do banking. I don't. The bank examination process. I was amazed when I read bank failure reports during the financial crisis, and I'm a law professor, so this is fun for me. I read dozens of these. I had no idea there are literally hundreds of government agents inside of banks looking over the shoulders and watching what they're doing. It was amazing to me. The real genius of this is that it solves the kind of information problem of ex ante regulation, because the bank examiners in theory can be watching the bank engaging in activity and seeing what the private gains and social costs might be. And then before the bank fails, sort of halfway between, be able to put things to a stop. So in theory, this is a kind of a genius regulatory approach, and we don't see it in other areas of law. I think kind of cool. Problem is, and we said this out in the paper, it's just doomed to fail. It's doomed to fail because the bank examiners can really not credibly commit to shut down bank activity, and the reason why is it's a kind of strategic game theory move where the bank moves first and says we're engaging in a particular activity, and then it presents a kind of take it or leave it offer to the examiners. You can shut us down or not. The bank knows that the costs of an examiner shutting down a bank or a particular trading desk or a particular activity the bank is doing is going to cost them something. Political capital, risks for them of shutting down activity that it turns out to be socially welfare enhancing. So just imagine the bank examiner calling back to Washington saying, I want to shut this bank down, or I want to shut down this trading desk. It's costly to them. And the bank, knowing that it's costly, will present a suite of activities where the social welfare is zero. They know we're engaging in too much of this activity, too much social risk. But because if they do that, the only thing the bank examiner can do by shutting down the activity is also make the activity worth a social welfare of zero, stop doing it. That means they're not going to shut them down. They don't improve social welfare because social welfare is zero in both states of the world, but it costs them something to shut down the bank. So the banks know that the bank examiners are going to be very reluctant to shut them down, so they'll engage in too much activity from a social welfare perspective, and the examiners can't really do much about it. I was amazed in the bank examination reports how prescient the bank examiners were about the problems that would eventually destroy WAMU. For years before WAMU failed, the bank examination reports detailed in chapter and verse exactly what the problems were. And these bank examiners dutifully filled out their reports, and they sent them back to Washington, and nothing happened. Okay, that suggests to me the regulatory veto could work, but it's just a political problem. No one has the political will to shut down the banks in this kind of dance. In closing, we don't have a silver bullet for this. We offered in some other papers with another co-author, I suggested that we pay bank examiners for performance, right? Give them incentives, and you might laugh, but go and read it and see, read it before you laugh. Give them incentives to shut down banks so that they're bearing some of the downside risk when banks fail. We also offer in another paper how you could auction off bank regulatory assignments to try to bring some market discipline to the regulatory veto. The one last thing I'll say is the one good part of Dodd-Frank, which really hasn't played out very well, is the idea of living wills. That reduces the costs of the government shutting down bad bank activities in theory. In practice, I haven't seen haven't followed them closely enough to see if that's actually what's happening. But that actually, something that lowers the cost of shutting down excessive bank activity could be a good regulation, because it could empower that move and make the cost of shutdown a little bit lower. Okay, I'll stop.
Peter, thank you for joining us.
Sorry. And this is called the fog of systemic risk. There's also a fog in finding Founders Hall. So I excuse myself for not being able to navigate the streets in Arlington, Virginia. Okay, this has really been interesting. I missed part of yours, Elizabeth, but what I've heard is really interesting. And I want to say one of the reasons I think that we have fog about systemic risk is that it's not that easy. It's not that difficult to define it. It's very difficult to determine what would cause it. Now, systemic risk is, to me, pretty easy to understand. It is some kind of event that causes a breakdown of most of the financial system. That's what people have been talking about. It's not that hard to understand. The trouble is we don't know what will cause it. And Dodd-Frank and the FSOC are engaged in a useless exercise because they have defined systemic risk incorrectly. Systemic risk basically is defined in Dodd-Frank and has been defined by the media and by many others as a question of interconnections among financial institutions. Now, we know from what happened in the financial crisis that interconnections is wrong. That does not cause systemic risk. We know this because Lehman Brothers was a gigantic firm, $650 billion firm. It failed suddenly, without any expectations on the part of people that it would fail. They thought, in fact, and I'll get to this in a minute, that the government would rescue it. But Lehman Brothers failed. However, and it was also a major player in the credit default swap market and in all of the other kinds of activities that were deemed to be extremely risky. However, no other major financial institution failed as a result of Lehman's failure. In other words, the interconnections between Lehman and others were not significant enough to cause, even at a time when the market was very nervous about the world at large and what was in the future and so forth, this gigantic firm fails and no other large financial institution fails, including all of those that were connected with Lehman through credit default swaps and so forth. No problem there. So if you assume that the issue is size and interconnectedness, and you are regulating on that basis, you are following the wrong path. Now, there was chaos after Lehman failed. We all remember that very well. But the chaos came from one thing, and that was the government. The government rescued Bear Stearns in March of 2008. And everyone, now Bear Stearns was a $450 billion firm, much smaller than Lehman Brothers. And everyone expected that the government had established a policy of rescuing all large financial institutions. But that policy was reversed with Lehman for reasons that have never been adequately explained, although in my book about the financial crisis, I do quote from Paulson, Hank Paulson, and Geithner, and Bernanke, all of whom said that Paulson said just before Lehman failed, "I'm not going to rescue anyone else because they're calling me Mr. Bailout." Okay, so for personal reasons, he allowed Lehman to fail. Now, it was a mistake in the first place to rescue Bear. But once they rescued Bear, they had established, it's a pure question of moral hazard, that government policy was going to rescue these large firms, and they didn't follow up. So all of a sudden, Lehman fails. Of course, people became then panicked. They didn't know who was going to fail next and what the government's policy was and whether the government actually knew what it was doing. All of these things caused tremendous fear and panic in the market, and that's why we had a financial crisis after that. Now, there is one way for systemic risk to occur, and that's as a result of correlated risk, as Todd said. Correlated risk occurs from time to time, especially when the government has been regulating a field, because regulation causes correlated risk. Regulators have only limited ways of overseeing industries. And what they want to do is make sure everyone does the same thing that they think is the right thing to do. And then all the regulated industries do that. And so that happened, in fact, in the housing market, because not only were banks herded into buying privately issued mortgage-backed securities because the government's capital regulations encouraged them to do that, but in addition, the government had regulations that, and this is again in the book that I wrote about this subject and in my dissent from the Financial Crisis Inquiry Commission report, the government also encouraged the sale of very weak subprime mortgage-backed securities in the hope of helping low-income people to be able to buy homes. And by 2008, more than half of all mortgages in the United States were subprime. And so when the huge bubble that was created by the decline in underwriting standards began to deflate in 2007 and 2008, these mortgages, these subprime mortgages, began to fail. And that was the reason we had a financial crisis. Not because there was greed on Wall Street, not because there was insufficient regulation of Wall Street, but simply the fact that we had loaded up our financial institutions with subprime mortgages. That was correlated risk. So one way you prevent correlated risk is to prevent the regulators from causing correlated risk by insisting that everyone act exactly the same in regulated industries. Now, it is actually, a poor choice of term to call something that is correlated risk contagion. That has gotten around too because Hal Scott at Harvard University has done an excellent piece of work that shows very, very clearly that it was not the interconnections between companies that caused the financial crisis, but what he called contagion, which is in fact a better word for that is either well, the best term for this is correlated risk, but another term could be something like common shock, I think would be another word, where all financial institutions, or many of them, are all holding the same kind of poor quality assets. And that's what we had in the United States before 2008. So when you get to cases like MetLife, where, and Adam is perfectly right in what he said, the FSOC is attempting to predict what would happen with interconnections in the future, in a state of the world that no one can know in the future. It's madness. It can't work. Not only that, they're following the wrong path because interconnections, which is the theory that they're using, is not the cause of the crisis. And if the real cause of the crisis, which is correlated risk, has to be affected, it can't be done by what the FSOC is empowered to do, which is cause much tougher regulation of individual firms. You have to have the whole industry released from the kinds of regulatory restrictions that cause them to take on the same assets. So the whole idea of systemic risk is being incorrectly used. The path that was laid out by Congress in the Dodd-Frank Act is an incorrect path for dealing with it. And so proper action here is to repeal all of those aspects of Dodd-Frank. Of course, everything else in Dodd-Frank ought to go too, but in this particular area, that would be a very useful thing to do. And we'd accomplish a lot by eliminating FSOC, eliminating its ability to declare that certain companies could create systemic risk, and start all over with reforming the regulatory system. Thanks.
Okay, so there's a lot to unpack here. We got about 29 minutes. I've got a couple questions I want to tease up for the panel here, and then we want to open it up to the floor. Let me see, Peter, if maybe we can start a panel discussion kind of where you ended here, which is about the idea that regulators ought to be doing, the way I take your comment is bespoke regulation. They ought to be institution-focused, institution-specific, as opposed to correlated encouragement of particular asset overinvestment, something like that, okay? So let's take a couple of recent examples. Let's see what the panel thinks about this. So, we heard correctly, as somebody who's lived inside of regulated institutions for some years now, that the big institutions have on-site examiners who live in the building and they see what's going on the trading desk every day. And yet, in the relatively recent past, we've seen several examples of major blow-ups, at least media blow-ups, if not real material blow-ups, inside of some institutions. Most recently, we have the Wells Fargo situation, where obviously there are literally thousands of OCC and Federal Reserve examiners there, and yet on their watch, you had 2.5 million accounts open for people who didn't ask for those accounts to be open. A few years before that, you had the JP Morgan situation with the London whale trade, not material to the JP Morgan income statement, but still a big loss on a heavily regulated trading desk. Those, it seems to me, weren't correlated issues. They were things that, all-knowing examiners could have caught if that's really possible, yet they didn't. So, Peter, maybe you can kick it off and then we can get the panel's views on, are those examples of the idea that individual institution regulation is inherently limited, or is there some other explanation there?
Well, yeah, I think regulation is inherently limited for all the reasons that we've heard already. Todd mentioned some good ones too, and that is that there's a lack of will among regulators. I'm a fan of market discipline because I think that creditors have the greatest incentive to keep the organizations that they've invested in from taking risks. But it's still useful in some respects to have regulators in the organizations if the regulators can pinpoint and publicize things that they think are troubling within the institution and call the market's attention to it. That would be, to me, of some use, but that's not the way the system works. As Todd pointed out, they make their reports, they go to Washington. The people in Washington don't have the will to take any actions based on that. We see that also in the whole prompt corrective action idea, which was adopted in Fiducia in 1991. And the idea was, if you see a bank's capital start to decline, you can start taking actions, not closing it down, but taking individual actions that would cut back on its risk-taking. It hasn't worked. The regulators are unable to do that, and one of the reasons might be that they don't actually understand the capital of the institutions. They don't understand how it's too complicated under the current capital regulation system. If we had a simpler capital system, like the one that has been proposed in the Choice Act, which is simply a leverage capital ratio, it'd be much easier for regulators to understand it and then point out that the capital of the institution is declining. So my view would be keep the regulators out to the extent possible, but make things simple for them. Maybe they would serve some purpose, but we have to rely mostly, I think, on market discipline.
So let me bring Todd in here. And Todd, say whatever you want, but while you're talking, answer this question. Are these scandals, is the Wells scandal or is the London whale, are those examples of the regulatory veto not working?
Okay, so let me respond first to something that Peter said, which I think is the most important, not surprising. Peter usually is insightful, and this was really insightful point that is at the core of all the problem. And then I'll answer your question. So he said regulation is what created correlated risk. So it's because regulators lack imagination. They are not innovators. They are lawyers. They try to fit things into boxes that they understand. And they're, in the idea of protecting the public interest, they're afraid of things that are different than what is presented to them. So, and because companies are risk averse, because of the power that, The government has a monopoly on violence. They're going to do what they say. So regulation begets conformity. And I mean, this is me parroting back to you 10th grade biology. The reason we're all here is because nature doesn't work that way. If the regulators were alive at the time of dinosaurs, there wouldn't have been little mammals climbing around in the trees. And then when the great big asteroid came, none of us would be here. Biology thrives because of diversification. And if all biological forms all adapted to one particular form of the climate, and then something exogenous shock comes and changes it, life goes away. Life exists and thrives because of diversity. So the remedy for the financial system is to have diversity in terms of who is lending money, who's engaging in financial activity. And every step the regulators have taken, why does Walmart not offer banking services? Because the regulators told them they're not allowed to do it, because the regulators are afraid. Oh my gosh, what if Walmart? No, we need diverse forms in every corner, big and small, offering financial services. And then when there is some kind of shock, the system will be more robust to it. Okay, to the answer of the regulatory veto, I'm with Peter in suggesting, in thinking that things that do not have a serious risk of putting costs onto the public are not things that regulators inside of banks should be caring about. So yes, in theory, the examiners failed by letting the London whale lose JP Morgan a few $1 billion, but none of us should care whether JP Morgan loses a few $1 billion. As you said, it's not material to them. The social losses from the Wells Fargo scandal, which is terrible behavior, is approximately zero. So if I was a bank examiner and people were doing this stuff, I don't think the government should really care that Wells Fargo cheated it and didn't cost their customers anything, but cheated and acted in bad ways. If I was the head of Wells Fargo, I'd fire all 5,000 people and move on. So I just think those particular examples are not things that should get the examiners, the regulatory veto that I'm concerned about, are particularly worried about. Engaging in massive risk-taking that has the potential to put those costs onto the government, that's going to be very rare. That's the kind of thing I have in mind. And of course, in those situations, the kind of political will is probably going to be at its lowest. So that's the irony.
Got it. So let me pick up just one more question, and then we'll go to the audience. But picking up on the issue of the political will problem, I've heard several panelists say that one of the weaknesses of the bank examination system is the idea that examiners, as in the WAMU case, might write up all kinds of findings of bad behavior, send it back to Washington, and in Washington there's not the will to do something about it. Do you think any of that changed post-Dodd-Frank in the following sense? So pre-Dodd-Frank, there was the concept of regulatory arbitrage and the idea that bank agencies were trying to sell their charters. In particular, you had the OCC and the OTS kind of competing for bank charters versus thrift charters. Some people perceived that the OTS was a weak regulator as a strategy for attracting business. WAMU, of course, was an OTS-regulated institution. But that's now all gone, and now you've got one agency regulating the entire banking system, that's the OCC. There's no more opportunity for banks to flee to a weaker regulator if they want to, or at least not the kind of meaningful opportunity there was in those days. Anybody on the panel think that's changed anything?
There's value in competition in a way. I sort of like, you say regulatory arbitrage, in a way it's regulatory competition, the competition among two regulators to prove both less inept at their jobs, but also more appealing in creating a regulatory structure that promotes both economic innovation and growth and also, some sort of public interest regulatory security. But I think it's hard to say whether what we have now is an improvement on that or not.
I doubt it. Concentration in the financial sector is higher now. The costs of shutting down big banks or big activities of big banks is enormous. Politicians in the run-up to the financial crisis talked about, rolling the dice with the policy about homeowners. And I think it's very hard, as Alan Greenspan said when he was Federal Reserve Chairman, the job of the Fed is to take away the punch bowl when the party's just getting started. It's really hard to take away the punch bowl when the party's really getting started. So everybody who was looking at the activities of the banks right before the financial crisis saw magic. Magic for shareholder returns, magic for giving people houses. We didn't all know that the Gaussian cupola function didn't estimate the appropriate amount of risk given the price in housing. Like, we just didn't know this. And we made a giant mistake, and then we learned that mistake. To Adam's point, I don't know what the next mistake is going to be. I'm with Peter in thinking it's regulation that forces everybody to do the same thing. And if that same thing turns out to be wrong, everybody's worse off. So, yeah.
Let me pose a question to the chairman over here, because you're the only one, I think, who's been operating under a regulatory system.
Peter missed my opening statement where I praised him and said I have no opinions. So go ahead, Peter.
Well, tell us. I mean, I do think that regulation has this effect that Todd is talking about. Have you found that? I mean, you operate in a very heavily regulated environment now with a regulator, and you're competing with another firm, that Freddie Mac. Is Freddie doing exactly the same thing as Fannie is doing, as far as you can tell, because of regulatory requirements?
Well, let me answer the question. I'll answer it in the way I can answer it, because I've got to be careful about what I say about Fannie and Freddie. But I've been inside of two regulated institutions, one a national bank and one Fannie Mae. And in my law practice, I represented lots of OCC and Federal Reserve banks and OTS banks, for that matter. And what I've perceived is it's clearly the case that regulators get uncomfortable with discontinuity among their institutions. So I remember, not in my current job, but in my previous job, I remember being told once by an OCC examiner that Bank of America was accounting for something a particular way, and therefore they couldn't accept us accounting for it a different way. I tried to explain to them just how much smarter I was than my Bank of America counterpart. That didn't fly, as I sat in my little office in Pasadena, California. But as it turns out, on that particular issue, I turned out to be right. And this was something we had to appeal all the way to the controller of the currency, and we had to make presentations and have data and everything. But the initial reaction by the examiners on the ground was, if a big institution is doing it this way and we've blessed that, that is the way it must be done.
Yeah.
And I'll tell you something, that's not just the regulators. Audit firms take the same view, which is if the bigger, if you're a PwC audit client and their bigger client in the same industry says X, they're not going to sign off on your statements unless you've done that. So I think that correlation principle is certainly consistent with things that I've said. What's a little bit different in my experience, I will say, at least post-crisis, is the idea that there are people in Washington who are afraid to shut down various activities. And I'll just tell you from personal experience, at multiple institutions, I have not found the post-crisis regulatory framework, and it may have been different 15 years ago, but today, if a bank examiner says that they're going to give you an MRA, does anybody know what an MRA is? I mean, an MRA is the worst thing that can happen to a bank if you're in the executive suite. It's called a matter requiring attention. And matters requiring attention sounds very plain vanilla. I actually don't remember my friend Jeff Miller teaching me that in his banking law class at Chicago, but I'm pretty sure it's in the book. I should have studied harder, yes. But the concept of MRA is you're going to have to change something, and you're going to have to change it more or less in the next 30 days, or you're fired. And it's not that the institution is shut down, but there's going to be a board-level accountability imposed because of whatever this matter is. And those things are handed out like candy. They really are. So if, for example, if you've got a policy that allows a particular level of manager to have a delegated authority to do trades up to $1 billion, and they think that person doesn't have the right qualifications, or they think the person's last, or whatever, they will come to you within minutes. They won't wait for the end of the year. They'll come and they'll give you this MRA, and if that guy's still employed in 30 days, then you yourself are hauled to Washington. Same thing with other particular things. There was the big issue with the mortgage consent orders 5 years ago, where all the big mortgage companies, mine included, were required to change practices across a zillion different dimensions. In fact, one of my lawyers in that matter was sitting back here just a moment ago. There was those things came out in a matter of weeks, not months. Once the foreclosure crisis started to hit, when the robo-signing stuff was in the newspapers, that was very rapid. So. All I would say is, pre-crisis, whether it's because of regulatory arbitrage or otherwise, there may have been some unwillingness in Washington to execute. Post-crisis, we may have overcompensated.
Right, and I think it's interesting to that point, Brian, and also Peter, you see this, you mentioned one of the examples, if you look at another example of this, which is kind of, I think, a bad combination of political will post-crisis and this kind of one-size-fits-all approach you've seen in the derivatives markets. I mean, you mentioned the CDS market, right, where Dodd-Frank imposed all of these central clearing requirements and CEF requirements and the like. And what's interesting, and it sort of goes back to the opening point about some of the tone deafness with regulators. I mean, without expressing sort of a normative view on this, what you saw in the public record, for example, in the swaps regulatory space under Dodd-Frank, is that the government came in with this idea, like these contracts, like CDS, are bespoke contracts. They're a way of managing risk. Lots of different firms use them to hedge different types of risk. They are bespoke, and they were traded over the counter for that reason. Market operated like that very well for a long time. Some of them are more liquid than others. And yet under the Dodd-Frank regime, there was political will to do something. So they come in with this kind of one-size-fits-all, let's force everyone into central clearing to mitigate risk, regardless of liquidity, regardless of market demand. And what was interesting is when you looked at the hearing records, both sides of the market, it wasn't just the sell side or the buy side, it was both were saying, we don't really want this. And we don't want it because we use this to do what you say you're trying to do, but you clearly don't understand, which is manage risk. And so it was sort of an amusing, but also scary example of how like the combination of political will and sort of uneducated, one-size-fits-all regulation comes together in some of these things in a way that's quite terrifying. And I think it might have been better, pre-crisis where there was some regulatory arbitrage and a little more quiet, or maybe lack of will than that.
Okay, so I know Adam had a comment, and then I do want to open it up. I know there's a lot of questions out here.
Can I just follow up on what Elizabeth just said, because it's a really important point.
You can arm wrestle Adam for the 30 seconds, but go.
Oh, is it only 30 seconds?
No. Go ahead, Peter.
Only go
That's,
ahead.
you're why everybody's here, so
Yeah.
go ahead.
No. This idea that you had to have mandatory clearing is so absurd in light of what actually happened when I talked about Lehman Brothers. Lehman Brothers was a major player in this market. It failed at a worst possible time, and yet all of the problems were ironed out. Nobody failed as a result of Lehman's failure in the swaps market. So, in other words, the whole diversified risk issue and the spreading of risk throughout the financial system worked. And yet Congress came in and changed the rule entirely to create something that does create interconnections. The very interconnections that they are hoping the FSOC will prevent, which it doesn't have to, that whole thing is now created by these mandatory clearing arrangements, plus the fact that the Fed is now given authority to step in with liquidity in the case any of these clearinghouses have problems.
The handful of clearinghouses, right.
Which it is doing exactly the wrong thing because it excludes private credit concerns about financial stability of these clearinghouses. It's an amazing thing, and if there's going to be a problem in the future in our economy, it's going to come out of that. The interconnections that have now been created through mandatory clearing, plus the government stepping in with liquidity in case any of these clearinghouses have a problem. I'm sorry, Adam.
Well, since it is the Center for the Study of the Administrative State, I do want to put a fine point on 2 points that came up during Peter's and Todd's presentations, because I think they're important. The first one is Peter mentioned at one point, well, let me just say, I think Peter illustrates that FSOC is looking through the wrong end of the telescope, and Congress is looking through the wrong end of the telescope. Instead of coming up with broad rules on what they think reflects a threat to systemic risk, and then finding firms that are running afoul of those principles, they're coming at it completely backwards. They're trying to seek out firms that they think are systemically risky, and then on a case-by-case basis developing prudential management standards within those companies. I think that's totally backwards. And then just second, really quickly, while Todd had illustrated that there are some forms of banking supervision and regulation that might be useful in the systemic risk context, those are applied to banks that opt into the banking regulatory system. The problem with FSOC is that it takes firms that did not opt into that process and it designates them for regulation. And that designation is itself an antecedent administrative law question that has to be judged on the record, on the administrative record.
Good. Okay, so let's open it up to the audience. I saw the first question, I think, is right over here.
Thank you. I appreciate you've certainly driven home the picture that the same diversification harangue we all get from our whoever advises us financially, whether it's my father or someone who's responsible for retirement funds, applies absolutely equally to the market for the financial industry. And it's very interesting to hear your correlated risk comments and creating, essentially stacking the deck for failure. With my history of suing agencies and being an attorney general who had a regulatory role, after the mortgage debacle, characterize it however you will, I remember searingly going to the Department of Justice uninvited. They did not want me there, along with a number of Democrat attorneys general. I was Republican, though that doesn't necessarily put you in a good category, more critically conservative. And once the ball started rolling that this group, federal and state, was going to address, and in their mind punish, the behavior they saw, the disconnection between the actual bad behavior, and there was plenty, and what the people driving the regulators, making the decision, because regulators will not decide to do this. I think it was Brian who commented on the sort of personality nature of a regulator. They will not pull the trigger. Elected attorneys general, the regulators in New York State, they will pull the trigger. And when they do, they're going to pull the trigger on a howitzer, not a gun to the head of one bad actor. And it was all I could do to try and not very successfully, as you could all see publicly, try and keep the discussion about our government reaction, if you will, contained to the actual bad behavior. Once that door was cracked open, it was blown open. And then the government response was not only out of proportion to the actual bad behavior, but it wasn't related to it. It was merely an opportunity to act. And because no one else understands those connections, they can get away with it. There's no accountability, even in the arenas where they might be accountable. And so I find that very, very dangerous. Not that I see a lot of good alternatives. I'm coming away with the conclusion of that societally we have to find the least bad alternative about how to protect ourselves. And not unusual for government policy analysis, but that's how I see this. And so that's a comment of someone who's been in that role. I have a question for Adam about that slide. I've litigated with many federal agencies. We're all familiar with one level of deference or another, Chevron being the most famous. It interests me as a litigator to be able to walk in to a court and argue against deference when the person responsible for deciding says we don't know how to decide. And I know you've participated in that activity. I'd appreciate your thoughts on where this stands from a defensibility standpoint, and maybe Elizabeth, having been at DOJ also, whether liking it or not, sometimes having to defend clients who are doing terribly stupid things. Of course, if clients didn't do that, we wouldn't need so many lawyers. So.
Well, okay, so first of all, I'm not involved in, while we filed an amicus brief in the current DC Circuit case, I just want to be clear, I'm not a main lawyer to that case. I'm barely a lawyer anymore at all, to the extent I ever really was one. But I do think that statements like this do cast doubt on the credibility of the agency. And to be clear, Geithner said this quote is from a 2011 report. It might have come from when he was still head of the New York Federal Reserve Bank. So I shouldn't imply that he said it as the sitting FSOC chair, although he may have. Here's the bigger problem. Here's why I think that the judges in the MetLife case will be skeptical and undeferential, or they should be, because deference to some extent is a deference to agency expertise. And the theory of FSOC is you had all these various stakeholder regulators around the table. They'll all bring their expertise from the SEC, the insurance community, the CFTC. In practice, FSOC has been an anti-expertise agency. In the MetLife case, the only person dissenting from the MetLife decision was the FSOC member who has expertise in insurance. He was telling everybody else, no, you're all misunderstanding this. This isn't how insurance works. It's being regulated, fine, you're doing it wrong. And the rest of the community around the FSOC table said, no, be quiet. We've got this covered. And you see the same dynamic with respect to its treatment of the SEC, where it's trying to it's spent a solid year or so trying to push the SEC into new regulations, where the SEC itself was saying, this is ridiculous. You're misunderstanding how this market works. And I think while the FSOC claims it seeks deference based on its purported expertise, if you're familiar with its operations, if anything, it's an anti-expertise agency and unworthy of deference.
Question over here.
So I wonder if I can, yeah, sure, Peter Conti Brown from the Wharton School. I learned a lot from this, but mostly just felt things getting stuck in my throat as I was hearing assumptions that I think should go a little bit tested. So let me sound a discordant note a bit, and then see how you react. So the confusion or skepticism about systemic risk not having any content, I'd agree with Peter Wallison that I don't see how that is true at all, or at least how it's different from any of the other discretionary granting phrases or clauses throughout the administrative state. In banking alone, unfair, deceptive, and abusive acts or practices, safety and soundness, they multiply, right? And systemic risk, actually, both by statute and regulation, has so many different definitional proxies attached to it. Now, it sounds like many people on the panel think those are the wrong proxies, but it's not true that it's not the right, that it lacks a definitional content. And I guess my question is, I mean, this goes back centuries in some sense, right? So systemic risk and banking regulation generally about panics is a lot like what fighter pilots say their job is. Boring almost all the time and then incredibly exciting. And indeed, that goes back to Walter Bagehot, who said the same thing about banking. So if that extremely excited moment is the banking panic, and the regulatory state is built around this idea of acknowledging limited information, saying, we don't know what the future thing will be, here's the architecture that will allow us to evaluate that in the moment, and the best actors to evaluate in the moment wouldn't necessarily be Congress. I guess my question is, how is this discussion different from any other slice of administrative law or delegation? Your answer might be, it isn't, and that we should go back to a pre-New Deal era, and that would be, I think, intellectually principled, and we might be hearing that from Professor Epstein later. But is that your position? Is that let's just abolish the entire idea of delegation? Because this would be non-delegation on stilts, because there are lots of intelligible principles limiting the delegation in systemic risk regulation. And so if it's not kind of a go back to 1932, then what is your limiting principle on this?
Well, when I had a chance to talk a little while ago, I was saying that I think that the right way to treat the market here is with private credit discipline. I think that has worked, generally does work, and the intervention of the government in regulation actually has the effect of moral hazard very often. People believe that the government is protecting them. Creditors believe the government is protecting them. And as a result of that, they exercise less discipline. So I think in general, yes, I think we ought to remove a lot of the regulation that we have of the financial world. In particular, there's one area where that's not actually workable, I think, and that is with banks. Now, unfortunately, the media, when they talk about banks, They are referring to bank holding companies with these very large subsidiaries. The bank itself, the deposit-taking institution, is a dangerous institution because of the way banks relate to the rest of the economy. That has to be regulated in some way as long as it is taking insured deposits. The holding company should not be regulated. There's no reason for the holding company to be regulated. But we do have to be concerned about banks as long as we have an insured depository system. If we didn't have insured depositories, government-insured depositories, we probably wouldn't have to worry as much about banks. But with trillion-dollar institutions that are backed by the government because of insured deposits, regulation, I think, is inevitable. And the question is, how do we make sure that there is as much diversity as possible among these institutions, even though they are regulated? And I don't have an answer to that, but that's what we should be aiming for.
Okay, so I think we have time for one more quick question right down here in the front, and then we'll have to call it a day. One more question.
I want to come back to FSOC. What's it for? We're in a financial crisis. Is it going to do anything? No. It's not in charge. It's a committee of regulators because Congress wanted to avoid the unpleasant decision of who really matters in the United States regulatory system. So is it going to be the Fed that acts? If it's the Fed, what are the restrictions on its limits to power? Is it going to be the Treasury? Why hasn't there been a national discussion of this issue? Why hasn't there been a decision, a regime, to use Paul Trucker's phrase from the Hoover book that was published this week? Why doesn't the United States have a regime that determines who does what in a crisis and what are the limits of that power?
So this is a great question, both policy and political. Who wants to take that on the panel? No one's touching with the 10th.
No, I will.
Okay, good. Adam.
The reason why we don't have a national discussion of this outside of the administrative context is because the fact that we have administrative agencies to solve this means that Congress and the President aren't taking responsibility for it themselves. The fact of the administrative state, the fact that it's out there as a substitute for litigation, ends up deforming in and of itself the quality of the conversations we have in Congress and the President. And I think it's incumbent upon the President and Congress to take these things seriously in spite of having the administrative state in the background willing to purport to solve all these problems for us. I could go on.
Plenty of time throughout the day. Thank you for those questions, and thanks to the panelists.